Mr. Hodges, can you please go through your claim for me?
My former tenants left the rental house in just disastrous condition. They left the house damaged. I've listed multiple ways in which it was damaged. They left the house extremely dirty, failed to clean it to any kind of livable standard. I spent over $17,000 rehabilitating the house, getting it back to the point where I could rent it. Hired a contractor who also hired multiple subcontractors to bring it back to a livable condition. There was extensive wall damage, which is documented in photos by the subcontractor who repaired the damage and then had to paint the whole house. There were mildew issues that were caused, according to the contractor, by the tenants and their lifestyle. I mentioned cleaning. I provided photographs of the necessity to hire professional cleaners after they left. I have significant landlord hours, which are chargeable at, I think it's $45 or $50 an hour. I have an electrician charge, which by lease is the tenant's responsibility. And then I have July rent, which I believe is owed to me. They vacated early. We had a verbal agreement that they would not have to pay July rent if they performed in certain ways, which they did not. And that included leaving the house undamaged, leaving the house clean, not leaving stuff behind, trash behind, that sort of thing. All of that's been documented. So those are the highlights. In my filing of evidence, I have a number of receipts that kind of prove the points and the damage. I have the move-in photos from when they started renting the property. I have the lease that's in effect, which documents a lot of their responsibilities that they did not follow through on. So this is my attempt to recover at least some of the expenses that I incurred in order to re-rent the property.
Okay. And let me see, the lease, I'm looking through the original document. I see lots and lots and lots of photos. Can you point to me where you have a copy of the lease? I think it might be in Mr. Harris's.
Yeah, it's section, I think it's under section 2. I think it's marked section 2. Let me look. I've got the paper right in front of me. It is paged. It starts on page number. I numbered the pages by hand in the upper right-hand corner. It starts on page number 1, and it says original lease referenced in all extensions.
Okay. Now I'm going to hear for a minute from Mr. Harris and Ms. Campbell. Or do you go by
It's fine.
pronouns? Okay, I just want to make sure. So I don't know how you want to present this, because it sounds like you have a kind of counterclaim that is a separate claim. Is that correct?
It's necessarily separate, Your Honor, mainly because the issue of him coming after us for damages is necessarily separate to the security deposit claim that we're making. Mr. Hodges has full right to come after us for anything that he perceives as damage, but he has a statutory obligation if he wants to utilize our security deposit funds for that. That's why it's necessarily a separate case.
Okay, so why don't you start by responding to his claim?
Yes, Your Honor. Savannah has a statement she'd like to share, and then I can get into some of the legal details if that's okay.
Okay.
I know that this court is not based on emotion and it's based on fact, but I would just like to share that reading Mr. Hodges' filing felt deeply personal and humiliating for me. Mrs. Freese's statements on the state of my home being a health and safety hazard was a blatant mischaracterization of the state of my home, which caused intense lingering anxiety for me. Upon looking at Bob's own filing online, his own personal pictures showed that most of the hazards that Mrs. Freese pointed to were pre-existing conditions. Both of her statements made me question myself and my abilities as a mother. And it's now a public record how Mrs. Freese feels about us as parents and people when none of that is based in fact. Additionally, having an ESA in my rental was specifically to help me manage my anxiety levels, and having Bob drop off a threatening note at the door to our new home felt incredibly threatening to me personally, and it triggered intense panic that I felt was done specifically to intimidate us into payment. I love that house. We made it a home, and I'm sad that my memories there are always going to be overshadowed by this claim against us. I would like this to be resolved today so that we can move forward and celebrate our new home instead of mourning the memories of our old one. Thank you, Your Honor.
Okay. And since you're giving a statement, can you confirm how long you guys were there?
5 years, Your Honor.
Slightly just under 5 years, Your Honor. About 4 years, 11 months, 4 years, 12 months.
Okay. And as it relates to the condition of the house after you left, I'm looking, well, yeah, why don't you just, I'll hear from you now.
There's a preliminary issue I'd like to address first, Your Honor, and you can find it in my filing on page 4. Number 1, the preliminary issue is that Mr. Hodges failed to service properly. He never sent us the service packet. He signed his own certificate of service. He did not hire a process server to send the letter. That's one of the first issues that we have here today, is that Mr. Hodges just failed to service properly. How we want to proceed based off of that is up to you. But that's a preliminary issue I'd like to discuss at least now.
Yeah, I think that issue has been waived just by the fact that services has to do with notice, and you have clearly received notice. So,
okay, that's completely fine.
Yeah.
I understand that. The other thing that we'd like to bring up is first, and kind of going through this in piecemeals is relatively difficult, Your Honor, because of just the kind of nature of this filing. There's pictures that aren't associated with proper claims. It's kind of just a dumping of evidence and invoices. So I've done my best to go through it and try to give the court an idea of what he's reasonably trying to charge us for. The number 1 issue that we can start with is that on the first page of his filing where he goes through costs, number 1 doesn't have really any itemization of these costs. He has miscellaneous for $230, which goes against the very foundation of the Residential Landlord Tenant Act. He does not have hours associated with any of these charges. He also has charges that are on this invoice for items that were clearly purchased after he already had new renters in the building. And you can see that through the Barry's appliance diagnostic, the McKinley's appliance, and the Walgreens photo, which all were handwritten after the filing was made. There's also, as it relates to the landlord hours, and we can see this in my filing as well, that there is no itemization as far as what took what amount of time, why he's owed $50 an hour, why that's actually reasonable to market rates for a landlord, which the RCW requires him to do. And beyond all of that, Your Honor, in RCW 59.18.280, it clearly states that he can't charge us for the full replacement of any items. And throughout this entire filing, he's charging us for full replacement of whether it's an appliance, whether it's drywall in the home, whether it's paint, and he doesn't associate any of the damages that he purports to take pictures of with any of these claims. And so the court and Savannah and I are left kind of wondering what these charges are necessarily for and why they have to be associated with us as tenants. Beyond that, the most fundamental issue in the case is that Mr. Hodges never had a signed move-in checklist. We never agreed to any kind of condition that the home was in prior to moving in. As a result, most of the damages, if not all of them, we purport are prior from when we moved into the home. And you can even look at Mr. Hodges' own checklist that he provides that's unsigned. And in that checklist, there are contradictions that Mr. Hodges makes throughout the filing. The fact that he says that we couldn't put in contact paper when his checklist clearly states that contact paper was already installed, where he said that we had holes and minor wear and tear to the walls that required an entire replacement of all drywall, when in his own checklist, it states that there were holes and nicks on the walls. His contractor is blaming us for moisture in the bathroom because of a rusty door handle and making wild inferences as far as how those would actually be caused, when in reality, his own checklist states that the shower already had rust on the actual rod. And so we are just left wondering, number one, how Mr. Hodges is making a connection between why the way that we lived in our house and ultimately how that's causing damage. Number two, he has completely failed in his obligation to provide us with a full and specific list with invoices that are susceptible to market rates. And most importantly, when we talk about the good faith nature of this filing, which is required by the Residential Landlord Tenant Act under RCW 280.18.260, it talks about the fact that he has to come in and with good faith argumentation, which he fails to do. This 746 electrician charge is a great example of it. That can be found, let's see here on what page. And I can just pull up the invoice, Your Honor, if you can't necessarily find it, but it's an invoice for $746 for a complaint that apparently was unfounded. There are no hours associated with this invoice. Beyond that, how, if somebody wasn't fixing anything at a home, how in any idea we could be invoiced for $700 as a standard service charge? That doesn't make any sense. And if we're paying at an hourly rate, the average hourly rate of an electrician is $45 an hour, and Mr. Hodges is charging us for $800 here without any explanation of where this money is coming from, how many hours this electrician worked, what they were necessarily looking at. And that is indicative of the entire filing, Your Honor. All of these are invoices for the entire amount of full items without going through any kind of depreciation calculation. The pictures that Mr. Hodges provides are only showing at most wear and tear. And Mr. Hodges also provides pictures that have no bearing on any of the actual arguments that he makes. Now, on his point of us owing rent because he apparently did not leave the lease or meet our lease terms, we can look to his own email in his filing that he sent to us, where on page, not 11, I'm sorry, Your Honor, just bear with me here. But in his own filing, he sends an email on page 12 that delineates what our responsibilities would be in order not to be charged July rent. And those were paying for lawn maintenance, which we did. That invoice is included as a part of my filing. The second condition was being out of the home and allowing contractors to work in the home, which we did. By May 13th, we were allowing full use of the unit for anybody to make any relevant repairs they needed to make. And then we needed to be out by June 7th and pay the entire month of rent for June, which we did. As a result, Mr. Hodges was able to get new renters into the building by July 15th. So we just find that the premise that we completely failed to meet our obligation when he was able to get renters in just over a month, we find to be made in bad faith, Your Honor. We don't think that that's true. And beyond that, we've met all of the obligations we were supposed to meet. So having us be responsible for July rent is simply, it's an undue burden in our opinion. But there is a lot more that I could say, Your Honor. This filing is 97 pages long, and it includes invoices that aren't associated with any of the argumentation that he's making. And he's asking the court and myself to basically go through this entire document to delineate what I should and shouldn't pay, when in reality that goes against the very foundation of the Residential Landlord Tenant Act, which makes it very clear that in order to try to balance out the scales of power between landlords and tenants, they need to be incredibly specific about why they're keeping our deposit and why they're charging us for these exuberant amounts. And ultimately, Mr. Hodges is seeking $10,000 in reimbursement. He has $18,000 in charges here, and it's completely unclear in terms of what out of that $18,000 he's actually trying to reasonably get access to in this court. And it makes it very difficult for us as prior tenants to come to any determination about what we should or shouldn't pay, just because of the nature of the filing.
Okay. Mr. Hodges, I'm going to give you a chance to respond, but I want to ask something real quick. I can't find that. These are all photos.
Okay.
I'm looking for his exhibit. Because if you look in here, these are all photos. Every one of them is a photo. They don't include like the lease thing.
I have that printed off, Your Honor, if you'd like to do it.
Yeah, let me take a look at this. Mr. Hodges, I'm having trouble accessing your filing, and so Mr. Harris here has brought me his copy of it. Do you have any objection to me looking through this?
No, not at all. It was filed with the court, accepted by the court. I'm not sure why you don't have access to it, but it was both paper and digital.
Okay. Well, I'm gonna look through this just real quick. So it's under 39260.
Yeah.
And then it says plaintiff and defendant exhibit. And when
Plaintiff.
I do that, and then,
there's one of the files.
oh, I see what you're saying. There we
Yeah.
go. Okay. It's just in the midst of all the photos. Okay. There we go. All right, let me look through this real quick. Okay, now that I have this open, Mr. Hodges, do you want to go through any specific response to anything Mr. Harris said?
He referenced an unsigned checklist at the start of the lease, which was he worked with green property managers on that. I provided the photos from their checklist. I don't know, signed or unsigned. I don't know whether there was another page that was signatures or not, but that came from Green Property Management. That was part of the lease that they signed. So the documentation of the condition of the house was there. That documentation does reference some minor issues in the house, but they were extremely minor. And I think if the tenants were honest about it, that they were extremely happy with the condition of the house, and the house was, I would characterize as like new. I do want to reference the statement that Ms. Campbell made. First of all, I'm really sorry that she has experienced some emotional trauma over the situation. I don't wish that on anyone, and I'm just really sorry she's experiencing that. I do feel like this situation that the tenants need to take responsibility for their part in this situation, but that doesn't mitigate the fact that that her feelings are hurt and that it has caused her anxiety, and I'm sorry that she's experiencing that. I have spent a lot of time documenting the issues which are in my filing of evidence. I collected as many receipts as I could. I collected narratives from contractor and subcontractors and the cleaning people. I think I have 90 some photos of the situation that I was left with. I really feel like I've documented more than sufficiently the condition of the house that I received from the tenants when they vacated. The tenants talked about the July rent issue, which I acknowledged in my own filing. I told them that if they performed, if they did the things that were in the lease and that we had agreed to verbally, that's fine. I would not charge them for July, but they didn't do that. And I referenced multiple issues in my filing that they didn't do. The lease speaks to many of those issues, which I'm happy to go through with you, but they just didn't perform. And that cost me a lot of time and a lot of money. And that really is the purpose of my asking for damages.
Yeah, 1 second though, before you respond. So Mr. Hodges, you're asking for a lot of money. Can you give me, just kind of walk me through the breakdown of what you're seeking?
I'm sure I can. Just a second. Let me find my summary.
Lance is in here.
So if you look on page 1 of section 1, section 1, page 1, that shows final accounting.
Right.
There is a list, a real specific list of damages and receipts. There is also a page 2A, which was my initial accounting, which the tenants referenced that I had delivered some threatening note of some sort to their new home. That was not the case. This page was what I delivered to their home to give them a heads up that it was, this is the preliminary accounting, this is what I'm working on, and that there would be more to come. It took quite some time to fix everything and to figure out, who we were going to hire and who was going to do what work. So that was the reason that there was both a preliminary and a final accounting. I don't know if I'm answering your question properly, but on page 1, there's the list of charges, and they're pretty specific. The tenants reference something about the landlord hours. I I was very specific, 18.5 hours at $50 an hour. I'm willing to change that to $45 an hour because I think that's referenced in the lease. That would change that number from $925 to $832.50. But you can see clearly I listed a lot of things that I needed to do. So I'm not sure why that would be called not specific. So does that list satisfy your question? Does that answer your question?
Well, in a way. I mean, so I'm kind of going through the list here.
Uh-huh.
What, in your opinion, was the cause of the mold issues and the water damage issues?
Lifestyle. So I worked with a contractor on that who also hired several subcontractors, and that was the conclusion. I mentioned, I think I mentioned in the attempt to mitigate, that the tenants during the 5 years that they were there lived with the windows shut. Apparently, I know that the blinds were down every time that I drove by the house or came by the house. There was no attempt, apparently, at to increase airflow or to run fans and that sort of thing. And that caused a significant mildew issue. At one point in time, I came to the house on another matter, and I noticed that there was some discoloring of the paint on some of the walls in the house. And the tenant and I discussed, what's going on here. I asked them if they knew what was going on, and I guessed at a couple things, but I didn't know what was going on either. I asked them if they wanted me to repaint or to mitigate the dark spots on the walls, and they said no. As it turned out, that issue, the mildew issue, which I believe they caused, and then the extensive but small wall damage, there's small bits of wall damage all over the house, that then caused me to have to hire a subcontractor to repair the wall damage and to repaint.
Let me just ask Mr. Harris and Ms. Campbell about the offer to mitigate dark spots on the wall? Did that happen?
No.
Was there any complaints about issues with the house during your tenure there? What kinds of issues were you having?
Correct, Your Honor. We reference in our filing under exhibit, and let me find that here. Just have to find. Yes, that's exhibit A, where we talk about moisture and stud staining communications in our response. That should be on page 37 and 38. In that exhibit, we clearly show how we had communication with Mr. Hodges about the dark stain on the walls in 2022 and 2023. Mr. Hodges also sent out a subcontractor named Scott to take a look at the dark staining in 2022. Over the course of our tenancy, obviously the stains would get darker, but Mr. Hodges never offered to, hey, do you want me to repaint? Do you want me to redo all of the sheetrock in here? That conversation never happened. And if it had, even if it had, Your Honor, and we had said no, that doesn't give Mr. Hodges the right to then charge us for that entire repair after we leave our tenancy, and instead to utilize standard wear and tear photos as the reasoning for why that repair had to happen. Even in his contractor's own invoice, she references how the correction for the moisture in the walls for the darkening of the studs would be repainting and redoing the sheetrock. And Mr. Hodges did not engage in that repair while we were still tenants. If he had, and then he had come to this court saying, hey, I repainted and redid all of the sheetrock in the home in 2022 because of this issue, and now they're leaving with all of these holes and minor scuffs and scratches, then maybe there'd be an argument there. But as it currently stands, we reported that issue years ago. He never addressed it, and now he's looking for post-judicial relief, at least in our opinion, as far as payment and correction of that particular issue. Now, beyond that, Mr. Hodges also says that he has statements from cleaners and subcontractors in his filing. That is, I can't find any evidence of that other than the singular testimony of his one subcontractor named Haley Freese. In our filing, we have an entire page dedicated to why that response is. Simply put, I mean, I have never received an invoice like that, Your Honor. I think any tenant who would receive an invoice for repairs where the predication of the invoice is based off of complete baseless assumptions of the tenant's lifestyle would find that to be not only offensive, but I mean, going against the complete foundation of the RCW, which is to provide a full and specific list. And the invoices that he provides are filled with social commentary about different generalizations about how we live our lives. And all of this stems after he sent us communications saying that we were going to be his adversary. That is what my wife, Savannah, is referencing when she talks about the threatening letter that he dropped off on our door. And you can find that in my 3926 filing, which should be present inside of the current, where on the last page, we go through not only the text messages that Mr. Hodges sent saying that we are now his adversary and he's going to come after us, but also the note that he left on our front door as an exhibit. Now, all of that, when we take it in conjunction with the email that he sent his own contractor on May 13th in his filing, where he dictates, these are all the things that I saw in the house. Did you find anything else? And she says, no, other than the garbage disposal. That email shows all of the things that he saw when he first came in to take a look at the home in May when we gave him early notice of leaving the home. After the adversarial communications, and you can see this in the timeline that I attach in my filing as well, that is when all of a sudden we owe $11,000. All of a sudden we owe $17,000. And all of it is predicated off the testimony of one individual who is basing all of her information on us off of seeing our house in a state of disarray while we're trying to move after being there for 5 years. And there's a lot more that we could respond to in Mr. Hodges' filing, Your Honor. My response is 76 pages alone. So there's a lot of stuff that I try to consolidate in that filing to make it very clear what Mr. Hodges is trying to come after us for. That's why I include the price point. That's why I also include the evidentiary timeline. But that is, again, my best attempt at trying to reason all these potential charges. And we just feel that it's completely unclear. But if you have specific questions about any of the charges that Mr. Hodges is purporting or our response to them, I'm happy to talk through it if you wish.
Okay. Well, I want to give Mr. Hodges an opportunity to respond. It's a little back and forth because I'm trying to make sure you both cover kind of the issues that are here. But Mr. Hodges, did you want to respond to what Mr. Harris said?
Sure. I'm sorry, I just don't agree with the tenants. I did offer to mitigate the whatever dark spots that were on the paint years ago. That was verbal, but I did offer to take care of it. It actually bothered me. I felt it bothered me more than it bothered them. When I made that offer, they did not want to do that because they said that it would provide upheaval for their family. They might have to move out or move stuff. So I don't know what to do other than say that, yes, verbally, I did offer to fix it. In some regards, I'm glad we didn't, because it would have just happened again, based on how they kept the house so tightly shut up. Then the tenants reference a list that I included in my evidence from May. And that's true. That's why they hadn't even moved out yet. That is what we found preliminarily in May. I didn't have access to go over the house that early. When they finally did move out, I think it was June 7 or June 8. That's when we had access to really figure out what we were gonna need to do to rehabilitate the house. So that preliminary list, yeah, absolutely, but that was not any kind of a final determination. They didn't move out till June 7, and that's when we were able to understand better the extensive damage and need to rehabilitate.
In their tenure there, which it sounds like it was approximately 5 years, did you do periodic inspections of the property?
Occasional. Obviously now I wish I had done more, but it would be anecdotal, probably at least a couple times a year, if not a little more. I would stop by to check to see if everything's okay. I would check that via text and email with the tenants as well. If something like needed a new garbage disposal or there was any kind of issue in the house, I would get that fixed immediately, and that would give me the opportunity to kind of survey the house.
Prior to this inspection that you did, looks like after they had moved out, had there been exhaust fans, working exhaust fans throughout the house?
Yes, 4 of them.
Were they found to be in functioning order when they moved out?
Yes.
All right, I'm going to let Mr. Harris respond to that.
Yes, Your Honor. We agree that we used exhaust fans all the time. I think that's clear from the photos that Mr. Hodges provided. I don't see how mildew gets into a fan if it's not consistently used. While we didn't check the inside of the fan, I think it's very clear that the house had a moisture problem prior to us moving in, based off of the checklist that Mr. Hodges provides that shows rust in the bathroom on the door handle. His own inspector doesn't even reference that checklist in relation to making us responsible for the rust that's in the bathroom. Beyond that, Mr. Hodges, we believe, clearly is not approaching this in a good faith effort in terms of trying to understand what we would reasonably owe him. I mean, the most important part about it is that we have no way of determining what the functioning life of any of the items in the home are in terms of what we would actually owe back. He's charging us for the full replacement of every single item that's on this list. He doesn't go through any kind of calculation to determine what the reasonable life of the items would be, particularly because we lived in the house for 5 years. And to Mr. Hodges' point of saying that I offered to fix it, even if by his own admission just now, he literally says, I'm glad I didn't, because the problem would have simply persisted. If that were associated with any kind of lifestyle change that we would have needed to make, then Mr. Hodges, that would have been his first suggestion to us when he saw the darkening. He would have said, hey, Mr. Harrison, Mr. Campbell, and Ms. Campbell, it looks like you have darkening in the house. Why are all the shades drawn down, and why is there so much moisture in here? That seems to be the cause of this. And then we would then change that lifestyle. But Clearly, he never had that conversation because that wasn't an actual issue in the home. We didn't have mildew everywhere. The house wasn't moist at all times. And the idea that because there's moisture existing behind a wall, that is immediately associated with something that we did and not what could be going on in the attic, what could be going on behind the wall, what could be going on the siding on the outside of the house. I mean, there's a myriad of different reasons why there could be moisture in the walls. And Mr. Hodges didn't reference any kind of change in behavior when he came to check on that, nor did he offer to fix it. And even if he had, there would still be present wear and tear in the home, and we wouldn't be able to be charged for that. And he would still be responsible for addressing that particular fix monetarily, whether we're still in the house or not.
All right. Okay, so here's what I'm going to do. Mr. Hodges, I'm going to give you one last chance to respond on the issue of the claims you're making, and then I'm going to briefly hear from Mr. Harris on the claims he's making against you. Okay, so do you want to respond on anything he just said?
Yes. Do you want me to respond on what he just said, and or do you want me to provide a summary of all the stuff?
Both as quickly as you can.
Okay. Mr. Harris said something about that I should have, I guess, advised them to change their behavior or change their lifestyle or whatever. That's not my responsibility as a landlord. In fact, it would have, I think, just caused more anxiety and angst on their part. But that's really not my role to tell them to change their lives or lifestyle. The problem, we're just kind of focused on one small thing, but it was a very expensive fix. But the problem with mildew in the house, there was no problem for 10 years prior to them moving in. And there's been no problem for 6 months or however long it's been since they moved out. The problem was when they were there. And there wasn't, like I said, there wasn't a before, there wasn't an after problem. Mr. Harris referenced the shower rod in one of the bathrooms had a little bit of rust on it. I don't know about the doorknob, but that type of a problem is caused just naturally by water in the shower. It's not that is not indicative of a bigger problem in a house. And I totally that's fine if they want to not pay for replacing a shower rod. Perfectly okay, but that's not the big picture. The big picture is the fact that I had to repair and replace the sheetrock throughout the entire house. I provided lots of photos that showed the subcontractor going through the house and putting blue tape up all over the house. In some rooms, there were 25 or 30 marks on the walls that needed to be mitigated before painting. So those are really two different situations. Again, just a really brief summary. I have provided to the court the move-in photos that would show the good condition of the property before they moved in. I provided the lease. We haven't really had the opportunity to discuss the lease. The lease shows multiple places multiple things that were the tenant's responsibility that they did not follow through on. If you want, I'm happy to go through that. I provided over 100 photos that were taken after the tenants left that showed damage to appliances, damage to the walls. That showed how incredibly dirty the house was when they left it. It showed trash that was left that I had to take to the dump. So like I said, I've tried really hard to not be emotional and just show the things that as they were when I had to rehabilitate the house. And I think it's really clear in the documentary evidence that I provided what the house looked like when they left and what my expenses were, shown in the receipts and the list of damage.
Right. All right, thank you. All right, Mr. Harris, before I rule on this, because they're kind of connected issues, do you want to provide your claims that you're making against Mr. Hodges?
In relation to the security deposit, Your Honor?
That's your separate one that's under cause number 39261.
Yes, Your Honor.
Could I interject for just a second?
Yeah.
So I don't know about this claim. I have never been served. I haven't seen anything about this claim at all. So I'm a little bit at a disadvantage.
Your Honor, the nature of the claim is whether or not we can withhold, whether he can withhold the security deposit and whether he would be owed to double damages per this court's purview. In the last time that I came into the court on September 5th, the presiding judge in my case, 39261, stated that because Mr. Hodges has a myriad of different addresses in the state of Washington and he hadn't responded to any of the certified mail filings that I had made to the 2 other addresses that he provided the court, that I would like to serve him over email or electronically. The judge in that case said, that is fine. We will allow him to serve you allowed to serve him over email. All you have to do is include information showing that he opened the email. That way I know that Mr. Hodges actually saw it. And that's exactly what I included in my certificate of service. I had a separate individual send the email from their email account. There's a mail tracker associated with it. It shows that Mr. Hodges opened the email, he read the email, and that's why we have the certificate of service in the case in front of us today.
Okay, if I could respond to that, that is not true. First of all, I travel quite a bit. I was out of the country for most of the last month or so. I did receive 2 emails from an address that unfamiliar to me. I literally just noticed them a couple of days ago. I did not open them, so there's no way you're going to provide proof that I opened them. And I still don't know to this point what's in those emails.
Your Honor, there's a mail tracker associated with it. He opened the email.
Okay, well, I'm gonna hear from Mr. Harris because you're both here today. I'll give you a chance to respond. You'll be able to hear from him, and then I'll make a decision after we hear what the information. Go ahead, Mr. Harris.
Well, Your Honor, in terms of my case, it is very simple. If we look at our evidentiary timeline, we can see that at the moment that we stop responding to Mr. Hodges' text message after the relationship, by his own admission, becomes incredibly adversarial, that is at the point when all of these charges skyrocket in terms of what they would necessarily, what we would have to owe. But beyond that, the most important part of this filing is 3 main arguments. Number 1, Mr. Hodges has a statutory deadline to provide us with a clear and specific list of any of the issues inside of the home. He failed to meet that statutory deadline. He did not provide us with a clear and specific list of the damages. He doesn't make an argument in a response to this filing, but he does mention in his own filing that he ran out of time to provide, to actually get us access to any of these numbers, when in reality, every single invoice that Mr. Hodges includes in his filing, other than the purchases that he made after he had new tenants in the actual unit, all of those invoices come before July 7th, every single one. The only other invoice that wasn't available to Mr. Hodges prior to the 7th was his blind invoice, which is ordering an item online off of Lowe's. That doesn't have any kind of labor associated with it beyond the fact that we have to order a physical item. And we can talk about why we shouldn't necessarily have to pay for that on a different date based off of the photos that we provide. But as it stands, Mr. Hodges failed to give us a complete and full and specific list within 30 days. He did not provide us with a signed move-in checklist as a part of that list to dictate why he would be charging us certain items. He is charging us for clear wear and tear violations, and he took more of a security deposit than he was statutorily allowed to. On top of everything, we just believe that Mr. Hodges has approached this whole process in just incredible bad faith. I mean, the fact that we paid all of June, left a month early, gave him 2 additional months to take a look at the home, and he wants to use that as reasoning as to why we would necessarily have to pay him even more money because it's a preliminary check, I think is very indicative of the actual response of the filing itself. But we feel our filing is very clear in terms of all the different things that Mr. Hodges necessarily did to violate the law. And as a result, we feel that we should be entitled to our entire security deposit amount and double damages if the court finds that as well.
And so what's the specific amount? I think I wrote it down.
The specific amount was, I believe, $3,600 or something.
3560.
3560, which is totally fine. And if the court would feel it within our right to award us double, that would be fantastic. We understand if that's not the case.
Okay. All right, Mr. Hodges, did you hear what they're claiming here?
I did hear that.
Okay. How would you like to respond?
First of all, let's talk about RCW 59.18.280. In my filing, I noted that in that RCW, it clearly gives the landlord the opportunity to show that circumstances beyond my control prevented me from providing the statement and documentation within 30 days. This situation is exactly what that statutory language speaks to. It took us a tremendous amount of time to figure out how to mitigate all the situation and all the damages that the tenant took. There was no way that we could do that job prior to, I don't know when he might have expected it, but the end of the lease wasn't even until the end of July. So I would have had till 30 days after the end of the lease. But even if you count from the time that they vacated, there was not enough time to rehabilitate the house and understand all the damage in that 30 days. That's why that statutory language is in there to provide some protection in these egregious circumstances. The tenant said something about that I ran out of time. I really don't understand what that's talking about, that I had 2 additional months to look at the home. That's just not true. They vacated the house on June 7th and left it in a horrendous condition. And that's the first time that I had an opportunity to start the actual work on the house, to start driving stuff to the dump, that sort of thing. So I just, given the statutory language in the RCW, I think clearly that the timeline that I followed was legitimate. Again, clearly the lease didn't end till July 31. So that's how I feel about those specific charges.
Okay,
In response, can I maybe respond to that?
you can respond.
If you look at my exhibits inside of my filing, you can see that Mr. Hodges' contractor started work at the property on May 19th, looking over the attic, doing work in the property. That gives Mr. Hodges over 50 days to delineate any additional damages that would be associated with the house. Beyond that, if you look at my other exhibit inside of my filing, which is exhibit on page 22 in the filing for 39261, Mr. Hodges states on June 9th, 3 days after we left the property, that he was ready to show it. It's just, it doesn't make sense to us in relation to how there could be a $1,000 cleaning charge. I had to take an additional month to understand how much more damage was in the property, when in that same month, he had a person view the house 2 days after we left. And then beyond that, he also has, individuals that are under contract on the 15th of July. We left on the 7th and he already had people under contract a month later. Like the premise that he didn't have enough time to tell us what we needed to specifically pay for by July 8th, mainly because none of his invoices are after that date. All of the work that he was doing, he was able to get done significantly prior to that date. And then beyond that, the house was ready to show on June 9th, according to his own admission in his text. So we just, again, Your Honor, we feel as though he has flooded us in this court with a myriad of different items that we are now left to put the puzzles together for.
Okay.
And that's our
Okay, I'm ready to make a ruling, and there's a reason why I had these two cases kind of overlapping and hearing together. And obviously they are connected. I told you at the beginning, it's very helpful to use DRC because it's likely that neither one of you are going to like what I'm going to do here. But as I see it, and I'll start with your motion or your claim, Mr. Harris, is it seems to me to be a sad situation where you rented this place for an extended period of time, and it seemed like the relationship was good for a very long time, and then it wasn't right here at the end. There is sufficient evidence to support that the house was left fairly messy, that you left before the lease was up. And so there was a walkthrough done in May that showed sufficient things that needed to be corrected that would dictate the non-return of your security deposit. So first start, I'm going to deny your claim on claim number 39261. Okay, now to address 39260, this is where Mr. Hodges isn't going to like what I have to say. I don't believe there's sufficient evidence to support that the mildew damage was caused by your tenants and not some other condition. I do believe that a lot of these photos and a lot of the work that was done is normal wear and tear on the premises. As I just stated to Mr. Harris and Ms. Campbell, though, you have provided sufficient evidence that it was left in a state of disrepair and that you are entitled to retain the security deposit. However, the additional claims beyond that, I believe, are excessive and not supported by the evidence. And so I am going to agree that it was okay for you to retain the security deposit, but I'm going to deny your claim for additional amounts of money. And since I've denied both your claims, I'm not going to award either one of you return of your filing fees or services. Okay?
Okay.
All right. So I'm going to fill those out. We're done. And those orders will be available later online.
Thank you, Your Honor. Appreciate it.
Mhm.